Hi there, and welcome to the Employment Law Show once again. I'm John Scholes. Momentarily, Lior Samfiru will be on your screen. Partner and employmentlawyer.ca is where you'll want to reach Lior anytime. Employment Lawyer, obviously, 1-855-821-5900 to reach out to Lior. Help@employmentlawyer.ca. Got phone calls coming up. We have your questions from our viewers. We always have a main topic this week, the impact of tariffs for non-union workers. That is going to be in the second segment, so hang in there for that, and a lot of your questions as well. But Leo, we always start off with the week that was. That's how we get warmed up every week. What do you got cooking for this week? It's all yours, pal.
Hey, John, thank you. Great to be here, of course, and to cover this topic yet again. And we'll continue doing that because there's so many issues that come up and so many questions that I get asked every day. And, when I turn off the camera here and finish talking to you, John, I'm going to go back and answering emails. I guarantee you there'll be 40, 50 emails I've received just in these half hour with people asking questions. But that's what I want. Whether you're watching the show and learning or contacting me after, you should get right and have access to the employment laws that govern your job. Right? You have rights, whether you're really in any province in this country. We have some of the best employment laws in this country. If you lost your job, if you're being mistreated, if you're put on a temporary layoff, if your hours or compensation have changed, the law says not so fast. Wait a second, employer. Can't do that necessarily. Employees have rights. There's ways to enforce those rights that are fairly straightforward. So on this show, we try to cover that. But of course, 30 minutes is not a lot of time. It's not enough time to cover everything. So if your issue or question is not answered or addressed on this show, do the next thing that you can do, which is to reach out to me by phone or email so that we can have a private discussion so I can roll up my sleeves and get to work to help you address the legal issue that you're dealing with. We'll give you that contact information throughout the show. Remember, you have rights, and it's up to you now to make that call so that you can enforce them. But let's start off with the case of the day. I spoke with a gentleman that had recently, unfortunately, lost his job. The company was cutting quite a number of people from its workforce, and he lost his job as well. Now, first thing I noticed when I spoke to him is that his severance offer was, I was going to use a bad word, let's just say inappropriate, okay? He had been there for 6 years. He was offered 3 months of severance. He was owed about 8 or 9 months. So right off the bat, that was the issue. But there's another issue here that I had to push the employer fairly hard on, and that is his bonus. He'd usually receive a substantial bonus, okay, about $25,000 a year on average. And his employer said, well, that's a discretionary bonus. We can decide if to pay it, how much to pay it. So we don't have to pay you that as part of your severance, so we're not going to pay it. He was upset at that because he counted that on that bonus as part of his compensation. He's received it for the next few years. It was always in that $18,000 to $27,000 range, and he wanted it as part of his severance. Well, guess what? He was owed that as part of severance. Your bonus, average bonus, has to be accounted for in your severance. Doesn't matter if the employer calls it discretionary, if they refuse to pay it, if they say, well, we don't know what would have happened in the future. Does not matter. If you traditionally and historically earn a bonus, that bonus has to be accounted for in your severance. For him, over an 8 or 9 month period, that meant about $20,000 just on account of that bonus. So I wanted to remind everyone here that when it comes to your severance, salary, sure, your employer is not going to forget about your salary, but bonus has to be accounted for. But more than that, commissions, overtime, average overtime, benefits, pension contributions, car allowance, all components of your compensation have to be addressed in your compensation when it comes to your severance. So it's not just how many months you're owed, it's also what's included in that. For him, he was owed 9 months instead of 3 months, and total compensation, not just salary. We resolved the matter. He's getting what he's owed, but an important reminder not to take your employer's word for it, not to believe what your employer is saying. It's on you to get that advice. A good place to start is just to give me a call.
Lior, quite often the employer will say, it's discretionary. How many times, where's the window for it being, yes, discretionary, and then becoming a part of your regular income?
It's a fantastic question. Listen, if you just started working for the employer and maybe you received 1 or 2 bonuses, it may be a bit of a tougher go to show that you should be getting the bonus as part of your severance because there's not a lot of history there. But if you've been there for a few years and you can always show that you get the bonus and, the amounts may vary, but you get it and the time of year is right around the same, it becomes a term of employment. We have to look at it holistically. And if it's something that you can count on, it's part of your employment. It's a term of employment. And if it's a term of employment, it also has to be a term of your severance. And that's not a decision or an analysis that you have to or should make on your own. That's why I'm here in my team. We can help you understand if you're owed that bonus, what does that mean, what else you may be owed, so that you don't sign off on a severance package that's less than what you're owed.
Okay, the website you want to go to is employmentlawyer.ca. Find a radio station in your community that carries our show weekly and on the weekends as well. Lots of calls. You're invited to call into most of these shows and talk to us. Sometimes we get them back here on air. And we learn from them collectively. So, Lior, first call from one of our radio shows is coming up right now. Listen up.
Company relocating. I have a travel distance. Am I entitled to, or I guess what sort of severance would I be entitled to?
New location. Tell me how it's going to impact your commute. How much more you're going to have to travel?
About 2 hours. I don't drive. I take transit.
How long have you worked there for?
Coming on about 2 years.
And what kind of a job? How old are you?
Laboring, I'm approximately 40.
2 hours is a ton of time to your commute. Wow.
It's a massive difference.
Yeah.
And to me, kind of the threshold before an employer cannot force you to relocate is an hour. If by moving you're going to spend an extra hour over and above what you were spending before, that may be the type of change that your employer is not allowed to make. But when I say not allowed to make, does not mean that you can force your employer not to move, to stop your employer. Sorry, employer, you're not relocating or staying put. No. What that means is that if your employer is going to make that move and tell you you now have to commute an extra hour, hour and a half, 2 hours, you can potentially consider that to be a termination, a constructive dismissal, and then force the company to pay you severance. So you don't have to resign. It's not a resignation. It's not something where you have no choice. Now you're commuting the extra time. It's a constructive dismissal. For this person, our caller from the radio show, the change amounted to an extra 2 hours. That's a massive change. That's a constructive dismissal. So he can say no and get severance. The last question then, of course, is how much severance he's owed. Very easy to know and find out. We're going to use the severance calculator. You heard me talk about it before. You can find that at pocketemploymentlawyer.ca. Let's use that right now and see how much severance he's owed. So we know he's been there for right around 2 years in a laborer role. He's 40 years of age. You can see right there he's owed about 3 months of severance. And frankly, John, that's conservative. It could even be 4 or 5 months of severance. But right around that amount in severance, even though the company's not letting him go, they're just relocating him. Given the distance or the time that he's going to have to spend commuting to the new location, constructive dismissal, he's owed that severance.
Thank you so much for phone call number one, whoever that was. Phone call number two, Lior's coming up right now. Here we go.
My employer, when we started, it says that you're entitled to 3 weeks of severance for every year of service, but that only accounts for the amount of time that you worked. It doesn't account for your age or any of the other factors. Because they put this in the offer letter, and one would think that you would be pressured to sign that when you start, that's something that they can hold against you years and years later.
Great question. Great question.
Fantastic question. And it's literally a question where the answer could be worth hundreds of tens of thousands, hundreds of thousands of dollars, a lot of money. So employers are starting to understand that, wait a second, severance is a lot of money. So they're trying to reduce those severance obligations by having terms in an employment agreement that limit future severance. So you may be asked to sign an employment agreement that has a term that limits severance. Now, one thing I'll say is you can negotiate that. Happy to talk to you if you need to negotiate and to either eliminate that or make it less severe. But beyond that, even in cases where you ended up signing, you didn't know any better, you signed a clause that limits your termination entitlements, potentially you can get out of it. There's many ways to do that. And in most cases, we are able to get you out of that clause and still get you your full severance. So best advice is try to negotiate. Don't sign something because you think it's not going to be enforceable. But if you ended up signing something, don't assume you're not owed more severance. You may absolutely still be owed your full severance. We need to talk about it. We need to analyze that. Be very, very careful with what you sign. You don't want it to cost you tens of thousands of dollars down the road.
We will take a short break, Lior. On the other side, as always, phone call number 3 and our main topic, what you need to know about the impact of tariffs on non-union workers. That's coming up here on the Employment Law Show. Stay with us. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. John Scholes and Lior Samfiru. Of course, always reach out to Lior with your own questions when we're not doing this show. And you have plenty of opportunity and ways to do so. Phone call 1-855-821-5900. Help at employmentlawyer.ca. And the website, the only one you really need to know. It's got all the information we talk about and access, of course, freely and anonymously to the severance pay calculator. That is at pocketemploymentlawyer.ca. Okay, phone call number 3 from one of our radio shows, Lior, is coming up. Let's listen up.
So I have a family member. They were let go recently. They were offered a severance package. There were some issues prior to that about bullying and harassment by a manager. They raised it twice with the company and provided it in written format. And in the second instance, when it happened, they had to go on sick leave. They came back and were let go.
Not a smart employer. Not at all.
Not a smart employer, or I'll even say not a good employer either, because you don't do that if you're a good employer. So there's 2 major things that the employer did wrong here. Number one is it didn't properly address the bullying and punish someone that complained about bullying. Not legal. The second thing, of course, is that he was let go when he was off on a medical leave. Can't do that. Or coming back from a medical leave, probably because of that leave. Illegal, can't do that. So let's break both of those things down. If you're dealing with harassment, bullying in the workplace, you have to tell your employer, you should tell your employer, and then they must investigate. They have to take it seriously. They have to look into it in good faith. And of course, they have to do everything in their power, everything possible to fix that problem. Maybe they separate the people that are not working well together. Maybe they provide better training. Maybe they fire the person that's harassing. Either way, they have to deal with it. And what they cannot do is they cannot discipline or let go the person that complained about harassment. We call this reprisal. You're protected from any reprisal, from any punishment if you complain about harassment. It's completely and totally illegal to punish you. So sounds that way, certainly. This is what happened here. It's a reprisal. It's not legal. The second thing is, of course, the person obviously, because of the harassment, had to go off on a medical leave. It was obviously severe enough. And what happens? They're let go. Again, can't do that. That could be a violation of occupational health and safety law, human rights violation. That could be an employment standards violation, completely illegal as well. And beyond that, of course, it's just the wrong thing to do. Don't treat employees that way. So what I would tell this person is, given all the wrongs that the employer did here, call me. Let me help you get what you're owed. Let me help you fix that problem. And man, there's important lessons here for employees and employers. And employers, you got to do better.
All right, good stuff. Main topic time, Lior. As you know, we've entered the nasty and scary world of tariffs, so worldwide, but as it focuses here in Ontario and Canada for the most part. I want to talk how it affects non-union workers and what you can do and what you should know in that regard. Number one, can my employer make changes to my pay or duties as a result of the tariffs?
Listen, John, these are very uncertain times for many individuals and, of course, for companies, for employers across the country. We don't know yet how these tariffs are going to impact us. We don't know if it's going to be very bad, maybe not so bad. Is it going to result in high unemployment? Is it going to be a recession? And employers legitimately have concerns. And a lot of employers have already started feeling the impact. But here's the thing. And I'm talking from an employment law standpoint. The fact that employers may be affected by what's happening south of the border, by government policies, etc., does not give them new rights when it comes to employment law. And what does that mean when it comes to a person's job? That means that an employer does not have a right to reduce their pay, to change their job or change their hours, even if they're doing it in good faith, even if they're doing it for legitimate business reasons. Maybe the employer is just not as busy and they want to reduce hours. While I can understand that from a business standpoint, from a legal standpoint, can't do that. That can still be a constructive dismissal. So no, your employer cannot just make significant changes to terms of employment, even if it's because of tariffs, even if it's because the economic conditions dictate that. You still have rights. Constructive dismissal still applies. You can consider that a termination. Get your severance. You do not have to accept it.
All right, Lior, question number 2. Due to the tariffs, can my employer put me on a temporary layoff? We've seen that as well.
Oh, yeah. And I think if, in fact, are really going to have an impact, that's where I think the major impact is going to be on employees, these temporary layoffs. That's what happened when the pandemic first hit. Employers obviously were kind of shell-shocked, and they put employees, I understand why, on temporary layoffs. But again, just like back when the pandemic hit, same thing applies here as well. Your temporary layoff in most cases is not going to be legal. It's not legal. Even if it's because of tariffs, even if it's because the business is slowing down or the company is not doing well financially, they don't have a right to put you off work and kind of hope for the best and see what happens. If your employer puts you on a temporary layoff, that may give you, the employee, the right to consider that a termination and get your full severance. You don't have to accept it. This is another good example of the tariffs. The economic conditions do not eliminate employment laws, do not take away your rights. You still have a right to say, not okay with this temporary layoff, I just want my severance.
We're talking about how tariffs affect non-union workers. The third question is this one, Lior. Can my employer fire me because of the tariffs? I guess I mean fire without severance, right? Just let you go?
So you can be let go generally at any time and for most reasons, as long as severance is paid. So what your employer cannot do is they cannot use the severance as a reason to avoid paying you severance. Absolutely not. Even if the tariffs have impacted them, it's reduced their business, it's reduced their client base. Now they may not have as much money as they used to, does not give them a right to let you go without severance. Not at all. Full severance still has to be paid. So yes, your employer could let you go because of the tariffs. Yes, it could, because it can for pretty much any reason. But severance has to be paid. So an employer that tries to use severance as an excuse to not pay full severance is doing something illegal, and that, of course, would result in a wrongful dismissal.
Okay, so that, based on the fact that they still have to pay you severance, kind of brings about the fourth and last question for this week, and that is, how do the tariffs and the difficult economy affect the amount of severance, or does it affect the severance pay?
So it's easy to think and believe that, if your employer is struggling financially, there's tariffs, something that we never had to really deal with before, then maybe the employer gets a bit of a break and maybe they have to pay less severance. Well, I'm here to tell you that not only is that not the case, the opposite is true. If you lose your job when there's less jobs out there, or when it's an economy that's a difficult economy, a bad economy, not only do you get severance, you get even more severance than you would have gotten if everything was fine. The reason for that is if it's going to be harder for you to find another job, if it's going to take you longer to find new employment, that increases your severance. So what happens in a good economy? Well, good economy, arguably it's easier to find a job. There's a lot of jobs out there. Bad economy, less jobs, meaning it's going to be harder to find another job. More severance has to be paid. So the tariffs don't reduce your severance. If anything, they increase your severance.
Good stuff, Lior. We'll take a short break. We got some viewer questions on the way, and then we'll wrap up this segment like we do every week with the Employment Rights Rapid Fire. That is on the way as well. We'll take a short break now, get right back to it. More of the Employment Law Show is just ahead. Stay there. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. Thank you so much for sticking around through that short break. Lior is always up for questions after the show as well, and his colleagues and his team as well. That is 1-855-821-5900, help at employmentlawyer.ca. And the only website you really need when it comes to this topic, we've been saying it for years, and have access to the severance calculator, can all be found at pocketemploymentlawyer.ca. Okay, first question, Lior, comes from your live stream, which you do on YouTube and Facebook and LinkedIn. You want to join in on that, it is at stlawyers.ca. My mother, 67, was let go from a large nonprofit after 15 years in the position. They claim it was for poor performance, but she only received one verbal warning in the past year and no formal discipline. They're offering 3 months severance, even though they say it's with cause. Is that normal, and what should she do?
Oh, man. Okay, so this is what this employer is doing, John. It's saying, oh, we have cause to let you go. We don't have to pay you any severance. But you know what? Out of the goodness of our heart, we're going to throw you a bone. We're going to give you 3 months pay. But trust us, we're being generous because we don't have to pay you anything. Nonsense. Of course, you can hear that in the sarcastic tone in my voice. And that is because it is incredibly difficult to avoid paying severance, to terminate for cause. To let her go after 15 years for performance reasons, man, that's just not going to happen unless they had multiple warnings and she was doing a bad job almost on purpose. It's not going to be possible. She's going to be owed her full severance. Her employer is using that as an excuse to try to avoid paying full severance. We're not going to let them get away with it. Remember, it is extremely difficult to be let go for cause without severance. And you maybe are not living up to the standards that your employer set. Maybe your performance is lacking objectively. That does not mean that severance has to be eliminated. You still get your full severance. So for her, we know what this employer is doing is not legal. We know she's owed more than 3 months severance. So the last thing we need to figure out here is how much severance is she actually owed? Very easy to do. Once more, we're going to go to the severance calculator. It's free and anonymous and can be found at pocketemploymentlawyer.ca. You can check it out for yourself. Let's use that in this case and let's see how much we get. So she's been there for 15 years. She's a manager, 67 years of age. Her employer is saying, we're going to throw you a bone, pay you 3 months severance. You see right there, she's owed up to 20 months of severance. Not 3, not 6, not 10. 20 months of severance. This is a wrongful dismissal. Very, very common scenario. Employers often try to avoid paying full severance with inflated allegations of cause. Don't let that deter you from pursuing your rights. Just like with this person, use the severance calculator or call me.
You know, Lior, that number at the bottom, 18 to 20 months, seems like a lot, but she kind of hit the trifecta of maximum severance, pretty close to it. She's 67, going to be hard for her to find another job. She's a manager, and she's got over a decade, 15 years experience. Of course she's going to get paid, right?
Absolutely. When you're older and you work for a while in a more senior position, you're going to be right up there near the maximum. Maximum for most people is right around 24 months pay. For her, that's 20 months, close to it. But to think that they could get away with paying her 3 months, ridiculous, illegal, just not going to happen.
Does a nonprofit or a charitable organization, in this case, nonprofit, make any difference at all, or still got to pay?
They have to pay. They have to abide by the same laws as anyone else, not for-profit, for-profit, big company, small company, does not matter. Laws apply to everyone.
All right, second question from terminationquestions.com. By the way, you can use that resource free and anonymous as well, terminationquestions.com. I work in a specialized position. If I ever take a sick day, there is no one trained to cover my position. My boss has heard I'll be submitting notice to take parental leave soon, and I found out through the grapevine he will not be able to approve it. Can he do this? You can't.
John, you sometimes ask me, do we really need to talk about parental leave? Is that really a thing, a concern anymore? And you're right, it shouldn't be. But this is proof positive that it is. Your employer doesn't get to decide if they approve your parental leave. They don't get to decide if you get to take that time off, nor do they get to decide how long you're going to be off. This is an absolute right that you have. If you're pregnant, if you're going to be an expectant parent, father or mother, you can take that time off. Your employer doesn't get to do anything other than to make sure that they bring you back when the time comes to your old job, your old pay. And yes, it may be difficult. They may have to struggle to find someone. It may cost them money. The law says, oh, well, you have to do that. Okay, there's no leeway here. There's no, kind of tried but didn't really do it. You have to do it. So for her, yeah, severance is one thing. Forget about that, frankly, because it's going to be much more human rights violation potentially if the employer doesn't allow her to be off, employment standards violation. There's going to be other damages as well. Don't do that. And for employees out there, if you're taking parental leave, you have a right to that job back in most cases. If your employer doesn't give it to you, doesn't have a job, wants you to take another job, let's talk about it right away.
Quickly, Lior, in this case, I mean, they said it's a very specialized position. So from the employee standpoint, should they give a decent bit of runway for the employer to find somebody? Be fair about it? They don't have to, I guess, but...
They don't have to, but listen, I'm always a believer in courtey. I'm always a believer in good karma, frankly. So yes, if you can tell your employer in advance, hey, I'm going to be off starting this date. I'm giving you a few months to find someone. That is a very good thing. I'm sure the employer is going to appreciate it. You don't have to. You can take your parental leave and let them know even close to the last minute. That's okay. But certainly courtesy always goes a long way. Good idea, I think.
Okay, we wrap up the show again this week with the employment rights rapid fire. Let's get to it. Lior, rapid fire question number one. Can an employee still receive severance pay if they resign?
Generally speaking, no. A resignation doesn't get you severance. Severance is paid if the company lets you go. But if you resign because the employer did something that they're not allowed to do, they reduced your pay, they put you on a temporary layoff, they demoted you, changed your hours, or maybe they mistreated you, and because of that you resign, then it becomes a termination, a constructive dismissal, and you still get your severance. So the reason for the resignation may still mean that you do get severance.
Rapid fire number two. Can an employee be denied a raise or not given one, I guess?
Generally speaking, yes, unless there's an employment agreement that requires the company to give a raise, or there's some other agreement in writing that says, yes, you will get a raise at a certain point. Unless that happens, an employer does not have to give a raise. Now, of course, there's good business reasons and ethical reasons why they should, but they don't have to. But again, look at that employment agreement. If it says that you get a raise, your employer has to abide by it.
Rapid fire number three. Can an employee take sick leave without a doctor's note?
So generally speaking, the company is allowed to demand proof of your leave. Doctor's note is the best way to get it. If it's going to be a short leave, a day, you need to be sick a day, it'd be unreasonable to ask for a doctor's note. But on a more extended leave, yes, your employer is entitled to have a doctor's note.
Number four, can an employee refuse to work overtime?
Yes, you can. Generally, your employer cannot make you unless you sign an employment agreement that gives them the right and your consent to work that overtime.
And final rapid fire for this week. Can a remote employee be forced to work back in the office or in the office?
For most people, if you've been working remotely for a while, it becomes a term of employment and the company cannot force you to go back to work. If they do and you say no, if as a result of that you lose your job, that's not a resignation, that's a termination, and full severance would have to be paid.
And with that, we are saying goodbye. Reach out to Lior and his team now that we are done for this week. 1-855-821-5900. help@employmentlawyer.ca through email and pocketemploymentlawyer.ca as well. We'll see you next time.